Members, good morning. It's the appointed time, and we have a quorum. I call to order the meeting of the Bills Committee on Courts Remote Hearing Bill. The first item on the agenda is the election of Deputy Chairman. The Secretariat issued a notice before the meeting informing members that one valid nomination for the Deputy Chairmanship was received by the close of nominations. The member nominated is Mr. Ambrose Lam. According to paragraph 8D of Appendix 4 to the House Rules, if any valid nomination for the Deputy Chairmanship is received, the committee may decide whether it's necessary to elect a Deputy Chairman. I now consult members whether we agree to elect a Deputy Chairman. Any objections? All right, if we all agree, then I declare that Mr. Ambrose Lam be elected as the Deputy Chairman of this Bills Committee. Mr. Ambrose Lam may sit here with us during the meeting. Let me first invite the government as well as representatives from the Judiciary Administration to join us. Members, please refer to the latest agenda issued on the 17th of December for the papers. The first one is the paper issued on the 20th of November. It is a Legislative Council brief issued by the Administration Wing Chief Secretary for Administration's Office and the Judiciary Administration. Please also refer to the Legal Service Division report on the bill, LC paper number LS70/2024, as well as the background brief prepared by the Legislative Secretariat, LC paper number CB-21697/2024-02. Do members think it's necessary to invite public to provide submissions, or should we hold public hearings? If it is necessary, we will issue a notice on the website inviting members to provide submissions or attend public hearings. According to usual practice, we'll also invite district councillors from the 18 districts to provide submissions or attend public hearings. I can also pass on the submissions I receive to members for reference. So we can either invite written submissions or hold public hearings. What do members think? If members have no particular views, well, for this kind of technical legislative amendments, I think it's appropriate for us to issue a notice on the website, and we can invite written submissions from the public as well as the 18 district councils. Yes, Mr. Lai Tong Kwok. I agree. All right, we'll upload the notice on the website. We will first discuss the policy matters concerning the bill. The legal advisor of this Bills Committee on the 16th of December 2024 issued a paper. It is a letter to the administration. Please refer to LC paper number CB-21716/2024-01. This would help the Judiciary Administration as well as the government to reply to the legal advisor's questions. Now I invite Ms. Eva Yam, Deputy Director of Administration, to walk us through the bill. Members who would like to pose questions, please press the Request to Speak button. We will first discuss the policy matters concerning the bill. Ms. Yam, please. Thank you, Madam Chair. Good morning, members. The Court's Remote Hearing Bill seeks to provide for the application for and the operation and effect of remote hearings for court proceedings in Hong Kong. It will provide a clear legal basis for judges and judicial officers to order remote hearings at various levels of courts and tribunals, having regard to all relevant factors, as well as the dual requirements of open justice and fair hearing. Remote hearing is one of the judiciary's key initiatives on promoting the use of technology. This is in response to rising expectations from court users and the community to make greater use of technology in court operations. This would allow the court to better tackle unforeseen and complicated situations. I'm glad that the Legislative Council has formed this bill's committee swiftly. We will cooperate with the Legislative Council on the scrutiny of the bill. We hope that the bill can be passed as soon as possible so that remote hearings can be conducted where appropriate by the judiciary. I now invite Deputy Judiciary Administrator to tell you more. Thank you, Madam Chair. We submitted the LegCo brief earlier, which talks about the Court's Remote Hearing Bill. We have prepared a PowerPoint presentation today to brief members on the bill. First, I want to say that this bill provides for the court a tool so that under different circumstances where appropriate, remote hearings can be conducted. Remote hearings is just one tool for the court. It doesn't mean that after the bill is passed, all hearings or trials will adopt remote hearings. The bill sets out a series of factors to be considered by the judges before they make a decision on whether to hold remote hearings. Secondly, we understand that remote hearings aren't suitable for all types of court hearings or proceedings. For example, proceedings involving national security cases, as well as criminal trials and hearings before the juvenile court. Also, trials involving vulnerable witnesses. Remote hearings won't be suitable for all these types of proceedings. Also, without permission, no one can make recordings of any court proceedings. We would therefore like to take this opportunity to introduce new offenses as well as new penalties to criminalize these behaviors and conducts, to deter people from committing these acts. So these are what I want to say before I begin the PowerPoint presentation. As mentioned by the Deputy Director, this bill seeks to provide for the application for and the operation and effect of remote hearings for court proceedings in Hong Kong. We want to provide a clear legal basis for judges and judicial officers to take into consideration all relevant factors. Also, we have to adhere to the principles of open justice and fair hearings. Where appropriate, judges and judicial officers may direct a remote hearing to be held. On criminal proceedings, Due to the existing legal impediments, most of the criminal trials cannot be heard remotely. Normally, defendants at different stages of a court case, for example, during arraignment and trial, they have to physically be present. Since 2020, at different court levels as well as tribunals, remote hearings have been held for civil proceedings. There have been no particular restrictions for us to hold remote hearings for civil proceedings. However, we do find it appropriate to set out the provisions to regulate remote hearings for civil proceedings. Remote hearing refers to the use of live audio link. They could be telephone proceedings or live audio visual link. For both remote hearings or hearings held physically, the court proceedings will not be affected by the mode of hearing. Clause 9 of the bill sets out a series of factors to be considered in directing remote hearings, and it is only if these factors are satisfied as well as that the two major principles are satisfied that remote hearings can be held. A remote hearing order is a case management decision of the court. As mentioned, since 2020, at different levels of courts and tribunals, remote hearings have been conducted. So far, over 2,000 of these remote hearings have been held. So far, the feedback has been positive. After the bill is passed, where circumstances allow, we will hold remote hearings more frequently. In certain types of proceedings, such as 3-minute hearings, like hearings involving summonses, we will adopt the mode of remote hearings more frequently. A lot of the summons of times proceedings are held through telephone nowadays, and the legal sector has been quite familiar with this. And all along, the operation in this regard has been quite smooth, and this has been accepted by the legal sector as well. Before directing a remote hearing, the court must consider the list of factors set out in Clause 9 of the bill. These factors include the views of the parties. Please bear in mind that we're only referring to the views, not the agreement or consent of the parties. During litigation, certain parties may use different tactics to delay the proceedings, so we have to consult the parties on this. Secondly, we have to consider the ability of the parties to engage with and follow the proceeding. This includes whether there are devices from both of the parties to adopt the mode of remote hearings. Also, the maintenance of the rights of the parties should not be affected. The judges may also have to consider the potential impact of the order on the assessment of the credibility of witnesses and the reliability of the evidence presented. Judges will have to consider whether the right to a fair trial can be effectively maintained. Also, judges have to consider the quality and security of the remote hearing facilities and their availability to the parties. The court may make a remote hearing order either on its own motion or on application by parties. Before the mode of remote hearing is adopted, the court may invite parties to make submissions so that views of both parties can be considered.
If the court does not invite parties to make submissions prior to the making of the remote hearing order, if any of the party is dissatisfied with the remote hearing order, the party may make representation to set aside or vary the court's order within a period as specified by the court. And after considering the representations, the court may affirm, vary, or revoke the order as it thinks fit, and it will notify the parties of its decision. As I said, this is a case management decision. Should there be a material change in circumstances of the case, the court may vary or revoke a remote hearing order. I mentioned a number of proceedings that should be excluded. Now, the first type is proceedings involving national security. Well, whether we talk about civil or criminal proceedings, they should not be conducted through a remote media under the national security law. And any permission given or order made for remote hearing of any existing national security proceeding before the enactment of the bill is to be regarded as having never been given or made. So the effect of that is any prior evidence obtained is to be expunged. The second exception is criminal trials. We heard from the two legal bodies in particular that remote hearing is not suitable for criminal proceedings, for all criminal proceedings, and particularly when the physical presence of the defendant in court is of paramount significance. And therefore, the judiciary proposes not to adopt remote hearings for criminal trials. However, witnesses may still testify remotely. Now, for criminal proceedings, most of them do not involve criminal trials. For instance, 80% of the criminal proceedings in the High Court is about the proceedings. 9% of district councils are not really criminal trials, but criminal proceedings. Examples are bail applications or reviews, pretrial reviews, and call-over or mention hearings. We do not propose to use remote hearings in juvenile court because juvenile delinquents, well, they are younger than 16, and we believe it is better for them to be trialed in person. And we have special court settings for juvenile defendants. Usually they can be accompanied by their parents or guardians. Another exception is vulnerable witnesses. Under Part 3A of the Criminal Procedure Ordinance, Cap 221, we have special procedures set out for vulnerable witnesses, including a child, a witness in fear, or a complainant for a specified sexual offense, to testify by live television link in a separate room located in the same court premises as the courtroom. We believe this is a very safe and sound arrangement, and we have a mechanism to protect vulnerable witnesses and can be dealt with under Part 3 of the Criminal Procedure Ordinance. So we propose that this be an exception in the bill. Another exception are special procedures or in specific parts of proceedings. Now, at the time of the defendant's plea, verdict, and sentence, or for the defendant's first appearance before a magistrate, or with the personal safety of the defendant and the party and the nature of the evidence adduced to render remote hearing inappropriate, and when it is difficult for the defendant to give evidence freely. Under these circumstances, the people or parties have to be physically present. Now, open justice is a major concern. Upon passage of the bill, remote hearings will be broadcast in court premises, and the practice is just like the current one. When people interested in a certain trial can attend a court proceeding. And so in future, people who are interested in a certain proceeding will have to be in a certain location of the court, either the hall or a special room, and the remote hearings will be broadcast in court premises. If, in the unfortunate event that the courtroom or even court premises cannot be open to the public, we have to uphold the principle of open justice, and we have taken reference from practices in other jurisdictions. Now, people have to register, and then we'll provide a link with a password and user ID before people can receive the live broadcast. So these are really exceptional circumstances. I mentioned offenses and penalties. Since remote hearings are more susceptible to unauthorized recording and publishing of court proceedings, we consider it necessary to criminalize such conduct which may prejudice or interfere with the court proceedings. We will also enhance the deterrent effect and to maintain parity between physical and remote hearings. And unauthorized recording and publishing of both physical and remote hearings are criminal acts, as well as the broadcast of such proceedings. Anyone who has been convicted on summary conviction is liable to fine at level 5 and to imprisonment for 2 years, or on conviction on indictment to a fine at level 6 and to imprisonment for 5 years. Now, we've taken this opportunity to make consequential amendments in this exercise. Now we have to amend Section 7 of the Summary Offences Ordinance, Cap 228, on offences involving photo taking in courtroom premises. We will cover recording of other forms such as taking of audio records, videos, and live streaming on court premises, and publication of such recordings. We will increase the penalty of this offense to a fine at level 5 and to imprisonment for 1 year. We'll also take this opportunity to amend the Criminal Procedure Ordinance and the Hong Kong Court of Appeal Final Appeal Ordinance. That is, the attendance of a defendant is to be dispensed with unless the court gives the defendant leave to be present. Where the appeal is on some grounds involving a question of law alone, or in an application for leave to appeal, etc. Under the Criminal Procedure Ordinance, we have rules and provisions governing the taking of evidence from witnesses outside Hong Kong. Because we have a whole set of evidence, a whole set of rules for such circumstances, we are going to repeal the relevant rules and procedures. We plan to start remote hearings in criminal matters as appropriate in about 6 months after the enactment of the bill. For litigants in person, LIPs, they may need our support in participating in remote hearings, so we will provide bilingual guidelines, we'll arrange connection tests, and if they do not have appropriate video conferencing facilities or premises, well, they can do so in our designated rooms. We have got 7 rooms with such facilities, 1 in the High Court, 1 in District Court, and other in Family Court, and 4 in offices of our in the Queensway government offices. we have taken a while to put together the bill and also public consultation. In 2021, we consulted key stakeholders, including legal professional bodies and relevant government departments on the major principles of the bill. And then in June 2022, we conducted a 3-month public consultation on the draft bill and the operational arrangements. One range of views were received, and the two legal professional bodies also said that legal trials should not be conducted remotely. We've accepted that view. And then in May 2023, we consulted the panel on administration of justice and legal services with the general support of the panel. I end my presentation here. Thank you, Chair. Thank you, Mr. Yam, for your presentation. Now I open the floor to members. Right now we have 7 members who have pressed the request to speak button, and please do so if you're interested. I read out the order. Mr. Johnny Ng, Mr. Simon Lee, Mr. Lam Chun Sing, Ms. Maggie Chen, Ms. Doreen Kong, Ms. Yong Hoi Yan, and myself. Each can have 4 minutes, including question and answers. Please focus on policy issues. The first to go is Mr. Johnny Ng. Thank you, Chair. I'm very pleased to see that the Judiciary is making good use of technology to support the operations of our courts and to enhance efficiency. I believe the proposed bill can promote Hong Kong's status as an IP hub, so remote hearings can be conducted for giving with evidence and to make applications on IP cases. I'd like to know how this new arrangement will be promoted to other jurisdictions so that stakeholders know that this new arrangement will facilitate their protection of their IP rights. As we all know, technology develops by leaps and bounds. How can you ensure there is no cyber crime and cyber leakage? Because we know there are a lot of frauds online. How can you prevent that from happening? And we've also stepped up measures to ban photo taking and video taking in courts. I'd like to know whether you have new technology. Will you, because out there are devices to make it impossible for anyone to take sound and video recording, because this is a technology to prevent such offenses, and they're quite common nowadays. Will the courts use this kind of devices? Mr. Yam, thank you, Mr. Ng, for your questions, and thank you, Mr. Ng, for your support for the bill. We're not just talking about proceedings involving copyright. We're also promoting Hong Kong as a regional hub, a regional IP hub, and we will work with the government to ensure this is widely promoted. Mr. Ng is correct in saying that technology is developing rapidly. So when it comes to operation, we'll take note of the following. First, the system for remote hearing will be developed, maintained, and managed by the Judiciary. We have received funding support from the LegCo for the IT infrastructure of the Judiciary, protection of information, and IT security is something we set a lot of store by. And we have consulted the Digital Office of the government. So they provide us with updated guidelines from time to time, and we will take into account the views in enhancing our work.
人係需要用。
When there are witnesses that have to testify remotely, there's a camera that shows the witness's face, and there's also a camera that should show the background of the room where the witness is situated in. As mentioned, the credibility as well as the reliability of the evidence given by the witness is an important factor that will be considered by judges in whether to direct a remote hearing. Deepfake is becoming more common nowadays, and where necessary, we will upgrade as well as improve our systems. We have different arrangements for people who need to attend a hearing remotely. Say, for a legal representative. Before attending a remote hearing, he or she would have to register with the clerk to ensure that the identity of the legal representative could be verified. Also, the legal representative would have to verify the identity of the witness he or she calls. The Correction Services Department, for example, also has the responsibility to verify the identities of the defendants. We ask people who attend a remote hearing to show in front of the camera the identification documents as well. During a hearing, the judge may ask the relevant party attending a remote hearing to show to the court that there is nobody else in the room who may interfere with the witnesses when testifying. In relation to the use of technology to prevent people from making audio or video recordings, well, we adopt an open mind. We have a digital audio recording system ourselves. We make audio recordings during a court proceeding because we have to produce transcripts of the court proceedings. We have to make sure that such system would not affect the operation of a court proceeding. We'll also keep in view whether there are any new technologies available that would offer assistance to us. Please speak closer to the mic. All right, thank you. Dr. Simon Lee. Thank you, Madam Chair. I speak in support of this bill. Remote hearings have been conducted in different places around the world. This bill is a comprehensive one. I have two major questions. Just now, the Judiciary Administrator mentioned about safety as well as potential interference with the court proceedings. He said the judge may ask the witness attending a remote hearing to show to the court whether there is anyone around in the room. Sometimes law firms may be asked to provide evidence as well. Can you tell us about the relevant arrangement? Also, on exceptions to the use of remote hearings in relation to national security proceedings, well, according to Clause 5 of the bill, it says no national security proceedings may be conducted through a remote medium under the law or otherwise. So it is clear that national security proceedings will not be conducted remotely. However, Clause 35, that is Part 7 of the bill, concerning transitional provisions, it says that before commencement of the ordinance, taking evidence of by television shall be treated as withdrawn. It looks like this part of the bill is redundant. with Cap 122, we still have Clause 35 of the bill. Why is it the case? Thank you, Dr. Simon Lee, and thank you for your support of the bill. We adopt an open mind in relation to where the witness chooses to provide evidence. Of course, the camera will have to show clearly the witness's face as well as the witness's room. If law firms think it is appropriate to have the witness testify in the office of the law firm, this may be or would be allowed. Of course, if the witness cannot find a premises where they can testify, the judiciary would make the relevant arrangement. Dr. Lee is correct that under Clause 5, no national security proceedings may be conducted through a remote medium, and Clause 35 is a transitional provision. We hope that there can be transitional arrangements for existing proceedings that are national security proceedings. Sometimes at the beginning of a case, it is not considered that it is a national security proceeding. It is only during the later stage of the proceedings that the judiciary or the court decides that it is a national security proceeding. The court may make a case management decision and accordingly. So we want to adopt a more holistic approach. We want to be able to cover different scenarios under the bill. Upon the passage of the bill, all national security proceedings will not adopt remote hearing mode. For proceedings without final judgment involving national security cases, regardless of the legal basis, if certain evidence has been obtained through remote hearings, such evidence would be expunged. Well, I'd like to talk about the language we use during the meeting. I noticed that some members use both Chinese and English during the discussions, and I did not stop members. However, if too much English is used, members of the public may not be able to follow the discussions. We want interpreters as well as members of the public to be able to follow our discussions. So please try your best to stick to one language as you speak. I know that members have to cite certain terms from the bill, and it is inevitable that you have to use English sometimes, but please be aware of this. There are many technical details involved in this bill. I think the public cares about this bill, so we have to be mindful of our language. Mr. Lam Chun-sing, I have a couple of questions. At the policy level, by promoting remote hearings, will this help shorten the waiting time for proceedings at different court levels? I see that the waiting time has not met the service pledge. This is partly because we only have about 160 judges now. Say remote hearings may be able to be held because there aren't enough courtrooms, and this may help reduce the waiting time. You said since 2020, some 2,000 cases have been conducted remotely. Did you encounter any problems in these 2,000 remote hearings? For example, there's no internet connection during the middle of the proceeding, or certain documents or papers could not be submitted remotely. Also, were there any cases where someone who is not supposed to attend the hearing suddenly showed up during the remote hearing? Also, I'm quite concerned about the situation with the Labor Tribunal. So far, some 60 cases have been conducted remotely. In 2022, there were 38 remote hearings held by the Labor Tribunal, even during COVID. I don't know if you have been encouraging employees involved in these proceedings to attend hearings remotely. For those attending Labor Tribunal cases, they are not accompanied by legal representatives. They usually attend the court proceedings in person. Are they aware that they can attend hearings remotely, I wonder? Labor Tribunal cases are more straightforward. Normally, parties only have to submit records in relation to their working hours, for example. Or sometimes an employee was dismissed by the employer, and the employee may have found a new employer already, so they may not be able to apply for leave to attend these hearings all the time. Mr. Yam, in terms of the waiting time, it is affected by different factors. For example, it has to do with our level of manpower as well as our arrangement. We have been working with the government. We try to look at the situation holistically to see if we can improve our arrangement. Upon the passage of the bill with more remote hearings, we believe we'll be able to enhance the efficiency of court proceedings. For instance, 3-minute hearings concerning, for example, summonses. Normally, we have lawyers coming to the court to apply to have the papers submitted 14 or 28 days later. So this kind of hearings can be conducted on the phone so that lawyers won't have to commute to the court buildings. They don't even have to, for example, wait in the courtrooms for their case to be conducted. They can sit in their offices and wait for the hearings to be conducted. I believe this will enhance the efficiency of work of the judiciary as well as lawyers. As mentioned, since 2020, over 2,000 proceedings have been conducted remotely. The feedback we got has been very positive. In the past years, we have been trying to improve our facilities. At the beginning, we were quite strict with the IT facilities. However, starting from 2021, we have lowered our requirements on the devices required. Normal computers with cameras and those that can receive sounds could be connected to our remote hearing systems. So this is quite convenient for parties who have to attend hearings remotely.
Okay.
I've seen in a commercial case, a party to the litigant was in Beijing, so he could not be present physically. And the hearing was very smooth. He had to give evidence in Putonghua. As you may know, most of our hearings in High Court are conducted in English. So in that case, court interpretation was involved. However, the whole hearing was conducted very smoothly. Now, e-bundles are quite commonly used in commercial cases, that is, legal documents and also exhibits have been converted to electronic form, and sometimes there were arguments on when the document was signed, whether there was a witness to observe the signing of the documents. Well, things have been quite smooth, but of course there is room for improvement, and we will do as appropriate. We are happy to have suggestions from members. Now, for Labor Tribunal, we understand that employees may not be able to take leave from their work. Where appropriate, the court is happy to conduct remote hearings if employees do not have appropriate location for remote hearing. We have specified rooms in our judiciary for that to happen. Labor union representatives, if accepted by the court, can also accompany employees in appearing in such hearings. So, Mr. Lam, perhaps you can help us to publicize this in trade unions so that employees know that they don't have to be physically present. We have been publicizing this, but we'll be happy if Mr. Lam and trade unions can help us. Thank you. Ms. Maggie Chen. Thank you, Chair. I fully support the court's remote hearing bill, and I'm of the view that Hong Kong should have a comprehensive mechanism to deal with this. It will also be easier for people overseas to have access to our judiciary proceedings. It can also help to promote our rule of law infrastructure. Now, complicated trials will be excluded, but for proceedings alone, I think remote hearings can save both time and money. While I have seen the merits of remote hearings, and I understand that the court or the judge has to ensure fair and open hearings. Having set out the principles, I have a few questions to ask. Now, the decision to order a remote hearing is for the judge. If the judge orders a remote hearing on the court's own motion or on application by one of the parties, there should be a case management hearing. So this is number one, because if we don't have a case management hearing, one party may not be able to attend a hearing, or someone may have to babysit at home. Some may have hearing impairment. Some may not have the proper facility to attend a remote hearing on his own. And all these issues should be addressed at a case management hearing. And also, I'm concerned about the technical support. I understand that the judiciary will offer technical support. With the enactment of the bill, remote hearings may be more common. Will a hotline be set up for inquiries? because the technicalities may be difficult and people may not know how to operate the facilities. Will you have guidelines for users? Will you have a hotline that operates during office hour? Will that be done? Now, I have one more question, Chair. This is about the place for remote hearing. I understand that sometimes an overseas party is involved because if someone is already in Hong Kong, there is no reason why he cannot appear in person. I'd like to know whether there will be mutual arrangement with mainland courts so that court facilities can be available in the mainland to facilitate a remote hearing. And will our ETOs, Economic and Trade Offices overseas, provide premises for remote hearings? Ms. Chen, I'm afraid you have overrun. Well, this will be my last point. Please be succinct. Now, if an employee cannot attend a physical hearing, will there be facilities or rooms in our district offices, for instance, in the NT, to facilitate that to happen? In fact, Mr. Lam, Chan Sing also overran. I will allow for a second round, so members rest assured we have many members waiting to speak, so I hope the administrator can be brief. I believe Ms. Chen will follow up later, so please be brief, given that we have a few members waiting to speak. Mr. Yam. Thank you. After the bill is passed, we will issue practice directions on details of case management. There will be specific guidelines for the benefit of the legal practitioners and also stakeholders to follow, so members can rest assured. We do have case management conference. Please forgive my language. Such conferences will discuss the operational details, whether each and every part of the hearing will be conducted remotely, etc. We'll continue to do this. As regards technical support, any party to a litigation, if giving evidence in remotely, will be given a link with login password and login name. There will be tests. This will be done before a proper hearing. But of course, we are open to any suggestions as to what other support we can provide. We will certainly consider them. When it comes to cases involving a party in the mainland, we know that there are many legal officers in the mainland, someone who cannot appear in person. Now, we have cooperation between law firms in Hong Kong and in the mainland. So facilities and premises can be offered in law firms on the mainland as well. But let me reiterate, we're not talking about very sophisticated equipment. A simple computer will do. All is needed is just a quiet and environment free of distractions, etc. That will do. Mr. Ring Kong, thank you. I have a few simple questions. Now, the Law Society made a representation or a submission. The competition law cases were mentioned, and the Law Society has reservations about remote hearings in such cases. So I'd like to know what is your response to this view. And our AGLS panel, when this bill was given to the panel for consultation, there were views that there must be clear guidelines for the operation of the bill. I'd like to know how this will be done in practice. And secondly, like what Ms. Maggie Chan said, there should be sufficient training and assistance for our legal sector and members of the public, because if solicitors and barristers do not have sufficient training, that may interfere with the smooth operation of your scheme. And of course, many people are concerned about security and confidentiality. I'd like to know what undertaking and measures will be given by the judiciary to ensure this. Mr. Yam, thank you, Ms. Kong, for your questions. Of course, we are aware of the views submitted by the Law Society earlier on. In Clause 2 of the bill, for definition of court, we have a number of courts, including the Court of Final Appeal, the Court of Appeal, the Competition Tribunal, etc. The interpretation section gives a list of tribunals or courts for court, and that involves a number of courts where the judiciary is responsible for. We've heard the views of the Law Society, but different types of cases have their unique characteristics. Even with the bill passed, that doesn't mean that remote hearings is a must. The court or the judge will give consideration to a number of relevant factors in deciding whether remote hearing is appropriate and whether it will be better for the giving of evidence to be conducted physically. And so far, we have not used remote hearing in the Competition Tribunal yet. The court may order remote hearings for cases involving the Competition Tribunal, but the court will also consider the actual circumstances, and will also issue practice directions to give guidelines for everyone, including the legal sector, on the details of remote hearings. Meanwhile, the judicial administrator will give regard to provisions in Cap 638. The JA will issue administrative instructions to set out the requirements for the hardware and software of, audiovisual equipment, etc. There will be guidelines for people to follow. We have the Court Proceedings Electronic Ordinance, Cap 638. We give a lot of significance to the security of data. In our new district court complex, we have a new data center with funding support from the council. We will follow the requirements of the government, and the data center will be set up under the highest standards. We have different levels of firewalls, and we've also got detection systems for data security to ensure the integrity and security of data. And a special link will be given to a party in a remote hearing with a password as well as a login name to ensure that everything is safe and secure.
殷議員。
Ms. Eunice Yong, thank you, Madam Chair. Chair, I speak in support of this bill. I hope that after the bill is passed, the waiting time could be reduced and also the time for proceedings could be shortened. The waiting time for different cases, including those involving the family court as well as non-refoulement claimants, the waiting time has been long. I understand that the judiciary has been deploying security measures to ensure the safety of judges. I hope this bill can help reduce the processing time for each court proceeding and ensure the safety of judges. On the issue of deep fake, for defendant brought to a criminal proceeding for the first time, no remote hearing could be conducted. The defendant would have to appear physically. Say the defendant appears physically during the first time and afterwards remote hearings are conducted. Will you compare the facial features of the defendant when the defendant appears physically and remotely? If you have this facial recognition system, it can help ensure the safety of different parties. I think the judiciary have to work on the technology so that the proceeding will not be manipulated by deepfake. I just want to know if the court will be able to prevent people from impersonating parties involved in a court proceeding. Also, legal practitioners as well as members of the public aren't allowed to make audio or video recordings in a courtroom. I see that there are 2 levels of penalties to be imposed. Level 5 and Level 6 for summary conviction and conviction on indictment respectively. I see that people who break the law might be liable to imprisonment. The penalty is quite high. Did you compare the practices in different jurisdictions when you come up with this penalty? Thirdly, we see that there is great improvement in terms of the technology employed by the judiciary on audio recognition or audio to text conversion. Conversion from audio recording to text, is it against the law? Without simultaneous interpretation, some may use the technology currently offered by Google to convert an audio recording to text. I want to know whether legal practitioners will be allowed to make use of such technology to convert an audio file into text. Judiciary Administrator. On criminal proceedings, in terms of the security, well, Ms. Eunice Yong is correct that for defendants involving in criminal proceedings, they have to appear physically for the first hearing or first appearance. This cannot be done remotely. For the subsequent procedures or proceedings, including bail applications or reviews, remote hearings can be conducted. These are criminal proceedings, and the CSD plays a role in this. The CSD will have a mechanism in place to verify the identity of the defendants who attend the remote hearings. We have talked to the CSD in Lai Chi Kok as well as Tai Lam and Stanley reception centers as well as prisons. There will be rooms reserved for remote hearings. There will be facilities and devices for holding remote hearings as well, so that persons in remand can attend remote hearings in the reception centers. And that's the CSD won't have to escort the defendants to the court buildings. We hope to make use of the facilities to offer convenience to the legal representatives, the CSD, as well as to the persons in custody. Ms. Eunice Young asked about audio recordings. The penalty may be different depending on the prosecution. We have looked at practices in the UK, New Zealand, Australia, and Singapore. The fine level imposed by these places are more or less the same. Of course, we have to take into consideration the situation in Hong Kong as we impose the fine level. As we conducted the consultation exercises, the Law Society said the prohibited acts of making recordings and in courtrooms or court proceedings are serious matters, because this will affect the fairness of the proceeding. So the Law Society is of the view that the penalty should be heavy to create a deterrent effect and tell the public clearly that these acts are prohibited. On the technology to convert audio into text, currently we have a practice direction for court proceedings. We allow court reporters, for example, to make text record. So you see them typing during a court proceeding. I understand that audio systems or audio devices have become more popular nowadays. So our plan is to state clearly in the practice direction our requirement. We will allow legal representatives, court reporters to use devices with audio to text conversion function. The audio file may be kept in the device for some time before it is converted into text. This will be allowed. However, the audio recording cannot be stored or saved on the device. This will not be allowed. It may take 1 second or less than 1 second for the audio to be converted into text. This will be allowed. We will keep in view with the development of technologies to see what kind of devices or technologies will be allowed in a courtroom. So this is a question that was not asked by other members, so I allowed more time for the Judiciary Administration to respond. I have a question myself. Through AI, the computer could use my face and speak in different languages. Chinese, Cantonese, and English are quite similar. And sometimes it's hard to identify whether it is AI or the real person. I understand that you have been developing your own systems. Is that right? You have your own systems to manage the security, and you are going to deploy manpower to ensure security. So my first question concerns whether there are enough resources to do so. Second question. There could be problems with remote hearings not only for criminal trials but also during civil proceedings. A witness testifying remotely could be manipulated by a party off-screen. How could you ensure that the witness giving evidence remotely is not manipulated by another party, and that everything the witness says is voluntary? We are developing and managing our own remote hearing system. Of course, we have to fulfill the requirements imposed by the government, and we will ensure a certain level of security and safety, and we deploy manpower within the judiciary to do so. Of course, it is always better to have more manpower, but we will achieve all these using our existing resources. If there aren't enough resources, we will ask the government for more resources. Indeed, in May this year, we already realized that there was a need for us to build a new data center, so we asked for funding approval from the Legislative Council. So please be rest assured. The other point is about the rapid development of technology, and that there is some technology that allows certain parties to impersonate other people. We will keep you in view on the development of different types of technology, whether it is outside Hong Kong or within Hong Kong. We see there are different risks to different types of trials and proceedings. Criminal trials concerns or involves the personal safety of defendants, and we see high risks to these types of proceedings. That's why we do not recommend this kind of criminal trials to be held remotely, and this is echoed by the Law Society as well. In relation to civil proceedings, we think that the risks involved are relatively lower. There are different sectors set out in Clause 9J. It says that the measures to be taken is to ensure that evidence is given freely without coercion or other influence. So whether the witnesses are testifying in Hong Kong or outside Hong Kong, the judges will have to take into consideration the credibility of the witness as well as the reliability of the evidence presented. If the judge is of the view that the witness testifying remotely is not reliable and that the judge can tell from certain demeanor of the witness that the witness is not credible, then the judge may ask the witness to attend the proceeding physically. So the judge can exercise his power to make a case management decision based on the credibility as well as the reliability of the witness. The judiciary has different judicial cooperation arrangements with different jurisdictions. Our view is to provide a tool for the judge as well as the court. Judges do not necessarily have to use this tool, that is, the mode of remote hearing. If judges find it necessary, they may ask the relevant parties to attend the hearings physically.
Mr. Benson Look. Thank you, Chair. I fully agree with Dr. Priscilla Leung, our chair, in saying that there may be difficult jargons involved, but we should stick to a single language in discussing this, because this bill is not just important to our legal sector, it will also have profound impact on members of the public. So I hope we can examine the bill from the perspective of the public's interest. Now, for the justifications, the first sentence reads, in response to rising expectations from court users and the community in recent years, and also for enhancing the efficiency of our court. I'm sure members of the public would want to see cases being handled as soon as possible. Can the Judiciary further elaborate on how the overall efficiency of our judiciary can be improved by enacting the bill? For instance, how much shorter will the waiting time be for a listed case, for instance? And secondly, in the paper, it is pointed out that evidence taking can be done remotely. For the general public to understand our legal proceedings, their knowledge may come from our audiovisual works. They may worry that witnesses in giving evidence may be subject to manipulation and also influence, as depicted in some of the audiovisual works. So how can we make it clearer to the public so that we can get their support? Mr. Yam, thank you. Mr. Look, for your questions. In court listing time is subject to a number of factors. For instance, whether the case load is suddenly higher and whether there are circumstances making it impossible for courtrooms to be open, etc. With the passage of the bill, we encourage more remote hearings, but we do not have any indicators because the listing time is subject to too many factors. And for a case that is more complicated, the hearing may be longer, and that will have an impact on the overall listing time in court. I hope members understand this. But for sure, we believe efficiency can be enhanced. I mentioned 3-minute trials. Now, lawyers will no longer be required to commute to our court premises. That can help them to save time, and also legal fees may be lower because the bill on the actual hours spent on a case. If some procedures can be done remotely, if they can stay in their office, then I'm sure this is welcomed by many legal practitioners. They will be more efficient as a result. As for interference in giving evidence, as I mentioned in Clause 9J, the court has to consider whether evidence is given freely without coercion or other influence. So we have one camera filming the front of the witness and other camera filming the back. to ensure that there is no other person present in the same room. We have been doing this for a few years, and by and large, the proceedings have been smooth, and our judges and parties to litigation were happy or satisfied with the evidence taking process being done remotely. At the end of the day, it depends on the circumstances of the case, and the judge has the right to order a physical hearing anytime he seems fit. And if any party feels that things are not being done properly, there can be an application to vary an order. So different parties have the right to do as they think fit. Mr. Lam Sang-keung, now I've been discussing with the sector on the use of remote hearings. So far, I have not heard any objection from the sector. They only have views on some of the points. So I do support the use of remote hearings by courts in cases they deem fit. And as Ms. Mengi Chen and also Ms. Doreen Kong mentioned, sometimes there might be technical hiccups, and I've seen how manpower was required. A technician was called in to deal with the technical hiccups, and the case ended up taking more time. So I hope the judiciary will ensure that there is ample time for testing the equipments and things, etc., before starting a hearing. And the administration mentioned that witnesses can give evidence remotely overseas. And in Hong Kong, the giving of fabricated evidence can be subject to police investigation at once if a witness is overseas and he gives false evidence, then there is nothing you can do at once. So I hope there can be some provisions governing this. And the third point is on the giving of proof. Mr. Yam mentioned that publication of recordings is an offense. Para 7 is a defense. So long as there is sufficient evidence to bring out the point of dispute will do. So it appears that the burden of proof or the standard of proof is lower, because in clause 29 it is mentioned that a person is taken to have established a reasonable excuse for contravention if there is sufficient evidence to raise an issue with respect to the reasonable excuse. So is the standard of proof lower? Mr. Yam. Thank you, Mr. Lam, for your views. We will continue to enhance our system, and before a proper trial, we will conduct more tests to ensure that the remote hearing will be conducted smoothly and properly. Usually, before a remote hearing, we will arrange a time for different parties, including clerks to our courts, to conduct tests covering the sound and also image effect, and for evidence to be taken or exhibits to be displayed. Of course, that will be subject to the agreement of both parties before they will be involved in a remote hearing. We will continue to do this. We will try to minimize technical hiccups as far as possible. We'll continue to maintain close liaison with legal professionals and other stakeholders to see whether there is any room for further improvement of our remote hearing system. Clause 29 of the bill is about proof. Now, we want to provide room for the following. If sound or video recording has been done in court premises. Now, for instance, if there is suddenly a medical emergency, for instance, someone has fainted in a courtroom, we will have medical people to help, and if there is a demand from medical personnel to take video to note the physical condition of the person concerned, then that can be a reasonable excuse for making or taking photographs or videos in court premises. At the end of the day, whether an offense has been committed will be considered by the prosecution. There will also be inquiry with the judiciary to see whether approval has been granted by the judiciary before photographs or videos were taken. So there will be that will be the consideration, and that is a defense regarding reasonable excuse. Thank you. Next, Mr. Holden Chow. Thank you, Chair. There are different meetings carrying on, so if I ask questions already covered, please bear with me. When we consulted earlier on, I expressed my views very clearly. I have full support for civil cases, but I have reservation for criminal trials because people are concerned that witnesses might be subject to coercion or influence. Now, according to the brief, remote hearings will not apply to criminal trials, but for some criminal proceedings. And sometimes evidence giving may be involved. I have a practical question to ask. Now, for 3-minute trials or proceedings that are quite common, it really saves time for legal practitioners if that can be done remotely. But if someone is to give evidence in a civil case, I'd like to know whether the practical directions will encourage this. Or will you specify the premises and also the conditions required for doing it remotely? I don't know whether I should use the word encourage, or rather we should say that people are encouraged to give evidence in a law firm rather than in just any room to be arranged by the party concerned. Because if this is not done properly, this may give rise to other legal disputes. As we all know, in a case there can be various issues raised by either parties. So I've observed that in other jurisdictions, such as the UK, they are already quite advanced in using remote hearings. We're just beginning. So perhaps the judiciary can explain whether more specified or specific guidelines will be given in the practice directions. That is, people should not just use any other room for doing it remotely, because that may give rise to further disputes.
Mr. Yam, I thank Mr. Holden Chow for his support of the bill. I touched on this just now. For criminal trials, remote hearings will not be adopted, so please be rest assured. For other criminal proceedings, for example, bail applications, as well as callovers or mentions, to give you some figures, at the High Court, about 80% of the criminal proceedings have nothing to do with the criminal trials. At District Court, 90% of the cases are like this. So we think that for bail applications, we can adopt remote hearings more frequently, which will offer convenience to the parties involved. As mentioned, we have been working closely with the Correctional Services Department for Lai Chi Kok Tai Lam and Stanley Reception Centers. There are facilities suitable for persons in custody to attend hearings remotely for proceedings such as bail applications. For 3-minute hearings, we want to conduct these hearings remotely on a more frequent basis. In relation to the premises where remote hearings should be held, there are 7 rooms under the management of the Judiciary that could be offered. 1 at District Court, 1 at the High Court, 1 at the Family Court, and the other 4 are at the Queen's Government offices. These rooms can be used by parties if they cannot find a room where they can attend hearings remotely. We will prepare a set of practical directions, and we will, based on the views given by members, enrich the content of the practical directions. For example, we may include requirements on the choice of premises for parties to attend remote hearings. Mr. Lai Tong Kwok. Criminal trials cannot be conducted remotely according to the bill. I'm looking at Clause 6, Subclause 4, and Subclause 5. They set out the exceptional situations. Under certain circumstances, judges may order a remote hearing. Does that mean under certain circumstances, criminal trials can be conducted remotely? So it is not that all criminal trials cannot be conducted remotely. You mentioned that proceedings such as bail applications can be conducted remotely. Aren't these part of a criminal trial? How do you define a criminal proceeding? For a lot of criminal trials, computer software is involved or used. In the future, will you ask the parties involved to use the designated computer software or programs only if remote hearings are conducted? Say a witness involved is overseas and he or she has to use a computer software to attend a hearing remotely. How do you know if there are any bugs in the software program the witness uses? A relevant party may attend a hearing remotely will you allow the party attending the remote hearing overseas to get support or assistance from the judiciary of the jurisdiction where the witness is in to enhance the level of credibility or reliability of the court proceeding? Mr. Yam, there are certain exceptions under the bill. Under the bill, a witness may attend criminal proceedings remotely. So how do we define a criminal trial? We make reference to the Criminal Procedure Ordinance when we define a criminal trial. A criminal trial means the official trial. Before a criminal trial begins, there are unofficial trial proceedings, for example, case management or pre-trial reviews. There are hearings like these that have to be conducted before the criminal trial begins. These aren't criminal trials. For witnesses attending remote hearings overseas, well, we adopt an open mind in relation to the arrangement. We can think about how to enhance the reliability or the credibility of the witness through different arrangements. For witnesses attending remote hearings overseas, they are usually expert witnesses. There are usually no disputes to the evidence given by these experts. These experts normally just provide their knowledge during a hearing. If relevant parties are of the view that it is better to have lawyers in the relevant jurisdictions to observe the witness while the witness gives evidence, well, the relevant parties can come up with an agreed arrangement themselves. However, members' comment is noted. We will think about it. Mr. Paul Che. Thank you, Madam Chair. I think no legislative councillors or legal practitioners would object to this bill. This is because it encourages a greater use of technology to enhance efficiency. This can also help the judiciary tackle unforeseen situations such as pandemics. According to the administration, this measure can even help reduce carbon emissions, so there are no reasons for us to object to this bill. Well, we have already come to the legislative exercise. However, I do think that we have to sort out the policy matters. I agree that we have to enhance the efficiency of court operations. I'm not sure if Mr. Yam is practicing himself. A lot of time, lawyers are paid according to the hourly rate, and their time of traveling is included as well. I'm not sure if any legal practitioners or people from the legal sector would object to this because they would get a lower hourly rate maybe, or they may get fewer pay because of less traveling time. My question is this. We want to protect the rights and interests of defendants. defendants have to appear in the court for the first hearing. Some defendants claimed that they were treated improperly by the Correctional Services Department while they are in remand. Therefore, defendants have to appear in court physically for the first hearing. According to the bill, the Chief Justice could exercise his power to direct that a proceeding be heard remotely. I hope that more flexibility could be allowed for defendants. Exceptions to the use of remote hearings include national security proceedings as well as criminal trials. I understand that we have to ensure the credibility and reliability of witnesses. Well, this should apply to civil proceedings as well. In civil proceedings, judges will have to consider whether witnesses are credible or reliable. Judges have to observe the demeanor of the witnesses as well, and this is equally important for civil proceedings. For national security proceedings, I understand that for some cases it involves state secrets or confidential matters. However, for other types of proceedings, no important matters or confidential matters are involved. So we shouldn't be too rigid. We have to consider the rationale behind Mr. Yam. I've heard Mr. Che's valuable views. As we drafted the bill, we took into consideration giving flexibility to judges and judicial officers so that they have the options to direct a remote hearing or a physical hearing. Each case is different. Judges may exercise their power to make a case management decision. We are leaving it to the judges to make a decision based on the court operations. Thank you. Ms. Maggie Chan speaking for the second round, 2 minutes, please. Thank you, Madam Chair. We've been talking about the practice directions for legal practitioners on how remote hearings should be conducted. I think there should be a set of practice directions for judges as well. To give you an example, say there isn't stable internet connection during a remote hearing, and this affects the giving of evidence by the witness. Also, a witness may not be familiar with using the bundle, and the witness may choose not to use the bundle, and this is not ensuring justice. I'm looking at a case authority from the UK. It says that a remote hearing conducted by the family court concerning a protection order for a child, and the hearing was completed in 24 hours. And it says here that there was injustice in the proceeding. So what I want to say is that judges, when exercising their discretion, they have to ensure procedural justice and fairness to all parties. This is my first question and concern. Secondly, members of the public may apply to attend a remote hearing, and would you allow court reporters to do so? Under what circumstances a court reporter may apply to attend a remote hearing, and will they have to prove their identity? Thank you.
Fair and open hearings and justice is one of the most important considerations in the bill, and it's also our objective. Whether we talk about remote or physical hearings, ensuring justice is of paramount importance. So Ms. Chen can rest assured in the bill, as well as the practice directions and guidelines, will ensure that the arrangements can uphold fairness and fair hearings. Guidelines to the courts, yes, noted. And if remote hearing is used, and if a case is dealt with very expeditiously, will that lead to injustice? Now, let me say that open justice is also an important principle. We have a very mature judicial system. If the parties to litigation is not happy with the outcome of a hearing, then there is a chance to appeal. And how a member of the public, actually a reporter, can follow a remote hearing. Now, currently, all members of the public, including reporters, are required to follow a physical hearing in court premises, either in the courtroom or in extended areas of the court. We have TV to broadcast live a physical hearing. Now, if there are circumstances making it possible for courtroom or court premises to be open, then we will require anyone who would like to follow a hearing, including reporters, to register beforehand. And then we will send by email a link, a login account, and also the password before people can follow a remote hearing. We've explained why prior registration is required for everyone, including reporters, because we may worry that unauthorized voice or video recordings has been done. So prior registration will allow us to know who has followed a remote hearing. And the same approach is being used in other jurisdictions. So reporters, just like other members of the public, will have to register beforehand. Thank you, Mr. Lam Chan Sing. Two short questions. Whether a remote hearing will be used is entirely for the court to decide, and the views of the litigation parties will have a say too. Now, if one party objects, does that mean that the remote hearing cannot go ahead, or is it for the judge to decide based on views expressed by the party making that application? Now, you have excellent support for people with disabilities attending physical hearings. For instance, you have enlarged prints service, you have infrared arrangement, etc. I'd like to know whether the same can be provided for remote hearings. Of course, for some persons with disabilities, it is better for them to appear in court physically and accompanied by their family members. But what about remote hearings? The court, in deciding whether a remote hearing remote hearing order should be made will take into account views expressed by both parties. If one party objects, and of course the judge will hear its justifications, but at the end of the day, it is a case management decision to be made by the judge himself. Secondly, persons with disabilities. In Clause 9D of our bill, we say that the court must consider the ability of the parties to engage with and follow the proceeding if conducted through a remote media. Now, if a certain party has hearing or visual impairment, that will be a factor for the court to consider whether a remote hearing should be ordered. If the answer is no, then the court may decide that a physical hearing should be conducted. Now, I'd like to follow up on the issue of practice directions. I think you should give very clear consideration to the following. Now, you may not be sure whether the premises are suitable for a remote hearing. Of course, if it is in a law firm, all the best. But if it's otherwise, then you should increase manpower. Please do not give up the idea of remote hearing simply because you cannot ensure this. Now, I'm not saying that it's a must for all cases, but in some cases, you may have reservation about the suitability of the premises concerned. As said by Mr. Holden Chow, you may want to consider law firms in overseas jurisdictions. Will you consider this possibility? There may be insufficient manpower in the judiciary of the jurisdiction concerned. Now, if after consideration the court believes that there should be another person or an officer present to help, for instance, if going to make use of a law firm, if the law firm is renowned one, then can that be done? And sound recording by legal practitioners or court reporters, you said that that depends on the duration. Now, if the duration is long, you offer a defense for reasonable excuse. You have to make it very clear in your practice directions, because I believe this will be a point of concern for users. Thank you. Now, we have a lot of collaboration with law practices in the Greater Bay Area. So people may attend a remote hearing in the GBA in a law practice there. We will leave it to the sector. We've heard your views, and we'll see how we can elaborate further in our practice directions. But I hope members appreciate that we don't want the directions to be too specific. We should have room for other parties to maneuver. And as for devices to transcribe a sound input to text, now the sound recordings cannot be stored. There are procedures in the device to store the sound recording for less than a second during the transcription, and then it will be removed or deleted afterwards. We understand that this is a technical thing, but will ensure that the sound recording will not be stored for longer than that. That will be dealt with in the practice direction. Yes, sometimes it is just a technical issue. People are not too familiar with the system, so inadvertently they press a button to store the sound recording. You need to remind the users. Sometimes it is just a blunder. I have consulted with the deputy chairman. He will leave his questions to Friday because we are running short of time. We don't want a question to be left unanswered. Now, we may have to pause here. The next meeting, I know 2 members are still waiting to speak. So for the next meeting, we will continue with the Q&As. The next meeting is scheduled for 10:45 a.m. this Friday to 12:45. So see you on Friday. Meeting is adjourned.